In 1824, the Supreme Court handed down a landmark decision that would further define the powers granted the federal government in the Constitution. The case was Gibbons versus Ogden.
The case of Gibbons versus Ogden raises the issue of what happens when a state law and a federal law conflict.
The question there was commercial shipping. Who had the authority to license and grant permits for shipping on waterways within the United States?
The state of New York awards a monopoly to anyone that could operate a steamboat up the Hudson River at 3 knots from New York to New Jersey. And Robert Fulton, the inventor of the steamboat, is the first to achieve this. And Ogden is the driver of the steamboat that wins this monopoly. Thomas Gibbons, on the other hand, is operating a steamboat under the Federal Licensing Act, in which he gets a piece of document from the federal government that allows him to operate in the very same waterways. So there's the beginning of the conflict of Gibbons versus Ogden.
At issue in this case was the scope of the Commerce Clause in the Constitution that gave Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes.
Well, typically of Marshall, he reads Article 1, Section 8, the ability to regulate commerce as broadly as possible. Marshall actually rules using the Supremacy Clause, arguing that when state law and federal law conflict, that the federal law should prevail, the higher law would prevail, and so that the states lose on those grounds.
Now, this creates a very interesting question of constitutional interpretation. It doesn't really look like a fair contest to let the national government decide a dispute between the states and the national government. It looks like the national government is serving as judge in its own case, contrary to a basic principle of procedural justice. But the matter stood, and so to this day, we have a set of relationships between the national government and the states that was established by these early cases.